Welcome everybody. My name is Jeff Fowler, President of the Apartment Owners Association. It's great to have you with us today. Today we're going to be covering how to collect unpaid rent in the Bay Area. And so there's the process, and then there's actually being able to collect it, and at least we have to get the process right, even if there's not a lot of hope on actually collecting, but yet even still we still need to go for it, right? And so before we get into it, AOA has been around for over 40 years. We have an office in Alameda, and we service the whole Bay Area. And we are going to be having an in-person seminar in Santa Clara coming up in September, and also in Oakland as well in September. So 2 different events and 2 different topics. So take a look at both of those and then decide which ones you want to go to. And I'll be at both of those, booked, and I will be there. So I really look forward to meeting you if you're able to make those. And for AOA, really our goal is to give you information that'll help you stay in the know, help you manage your properties effectively, and just avoid all the pitfalls. And so we're real pleased to bring this content to you today. And for those of you that are not AOA members, there is a money-back guarantee for the first year of your membership. It's only $97 a year, and there are no per unit fees. So definitely join, sign up today, and we would love to help you. Really, our goal is to have the most successful group of apartment owners here in the state. And so we're working really hard to give you the information, the forms, the service, tenant screening, property management software, all the tools that you need to be able to do it well. And anyway, oh yeah, and if you would like closed caption, we're live on Facebook right now as it's going live. And of course, if you're watching after the fact, YouTube has the closed captions afterwards. And yeah, Larkspur, can you believe it? In Marin County, passed a rent cap, 7%, and then there's also a registration fee, I believe, that they put on that. So I think they're going to have a final reading on September 6th for that. If you're in the area, definitely write your city council members. And also, yeah, Burbank, San Diego, those things aren't going to matter, but we have a couple in-person events there. And here we go. So our speaker today, he has over 30 years of experience. He's the founder of Beckman, Feller & Chang. He's a real estate and landlord-tenant law attorney, so not just an eviction attorney. And his firm represents 7 Bay Area cities, so he covers a lot of ground there. So hopefully he's able to service you. And did you know he's been writing the AOA legal Q&A in our magazine since 2010? And so we're very thankful for that. Every single time he hits the hammer on the head when it comes to just the things that he chooses to include in that article. If you haven't seen that article, definitely open up the magazine and look at that one. All right, so it's my pleasure to finally introduce to you today Richard Beckman.
Since we first got acquainted with your father, actually. How's he doing? I hope well. But yeah, I appreciate the nod that, yeah, I do a lot of landlord-tenant stuff, but I do a lot of other real estate related stuff. Not a plug for me, actually, just, want to make sure that that's clear. And without, I guess, further ado, we can launch into the PowerPoint presentation. And as always, I'm a little technically challenged here. We have the great benefits of AOA's technical genius, Israel Paredes. So hopefully he will keep us on track, and you'll be seeing what we want you to see, which is the PowerPoint presentation for the most part. I'm not sure if I will remain on the screen or not. Possibly, hopefully not. But I will just kind of walk us through these issues. I will turn, I think, my gaze to my monitor, which is a bigger screen, a little easier for me to look at. So yeah, collecting unpaid rent in the Bay Area. And Jeff mentioned 7 cities. I mean, the Bay Area is really a collection of counties. San Francisco County on the west end, Marin County on the north end, or I should say northwest, Solano County to the far north, Contra Costa coming around the bay, Alameda, which is a giant county that encapsulates most of the East Bay as it's known, and then on the other side, San Mateo and Santa Clara counties. So a lot of cities within there, obviously San Francisco, Oakland, Berkeley, Fremont, San Jose. Um, so anyway, any of those jurisdictions we're pretty familiar with, some more than others, admittedly, but they're all similar, but each a little bit different in terms of their landlord-tenant laws generally, and certainly their pandemic moratorium provisions. Those have been all over the place, despite the state law that was passed in August of 2020, trying to bring some coherence to the mosh pit of local ordinances. There's still some uncertainty. And we're going to talk a little bit about that because there's not, for the most part, all of those ordinances have either recently concluded or are about to conclude. And so there's, just a little bit of time left. I mean, at the latest, August 31st. But again, we're going to kind of go through that. So without further ado, outline Alameda County, Berkeley, Oakland, San Francisco. It was just kind of the highlights. Those are the big ones. I mean, even though Berkeley and Oakland are in Alameda County, the funny thing is San Francisco, and I don't know if you can see my cursor, but I'm going to point to stuff if it's visible. San Francisco is the only jurisdiction in the state of California, which is a city and county in the same footprint. Everywhere else has a county and cities within it. And Alameda County includes the cities of Berkeley and Oakland. And that is relevant because Alameda County had a moratorium that was slightly more protective, I guess, of tenants, surprisingly, in some ways, than the Berkeley or Oakland ordinance. And it ended sooner. So there's a little tension between which rule actually applies from the end of the Alameda County ordinance at the end of April and the end of both Berkeley and Oakland at the end of August. But again, we'll go through that in a little bit of detail. So starting with Alameda County, the county declared on February 28th, after a lot of local pressure, you guys basically, to finally terminate the state of emergency upon which the moratorium was based. And it said it would be ended 60 days after the state of emergency. So basically, the eviction moratorium in Alameda County ended April 29th for all purposes, for relative to unlawful detainers. So after April 29th, there was no longer any need to go through the procedure of an ex parte application, for example, to file an unlawful detainer. They were no longer limited to just public health and safety. It was basically back to normal for issues that arose after May 1st, non-payment of rent, owner move-in, nuisance that wasn't quite a public health and safety hazard, all that stuff. So starting May 1st, landlords could begin to serve 3-day notices for non-payment rent that accrued as of May 1st. Now, again, this is Alameda County, not local cities, incorporated cities like Oakland and Berkeley. So it's important to make that distinction. Basically, the biggest, I think, provision for Alameda County units is that even after the expiration of the moratorium, while landlords can begin to serve non-payment of rent notices, cannot go back in time, cannot go back in before May 1st of 2023 to seek unpaid rent through a 3-day notice. That's a little different in Berkeley and Oakland. We'll talk about that. But Alameda was, pretty strict about that. Just any unpaid rent, and even if there's no provision even challenge the tenant, as far as I know. Basically, they just blanket statement, no unlawful detainers for rent that accrued prior to May 1st. All of that is available for collection. So, but we're going to go to the next screen to talk about that for just a moment. And I mentioned down here, if you're going to try a collection case, you have two options, basically. There's small claims court, which traditionally has a limit of $10,000 in dispute, and then above that, you have to go into what's called, I would just say superior court. Superior court is broken into two separate levels. There's what's called limited jurisdiction, and those are for cases that involve a value up to $25,000. And for anything over $25,000 in dispute, meaning your claim, your lawsuit seeks more than $25,000, you're in unlimited jurisdiction superior court. Kind of a historical note, they used to be called municipal court and superior court. And then in the mid-90s, the state realigned its court system and just made everything superior court, but had these two continued the same amount. Financial jurisdictional limits, 25,000 and below is now limited jurisdiction, used to be municipal court. Above 25,000 is now unlimited jurisdiction superior court. So depending on your amount of dispute, you'll file, and it has a little bit of difference. Mostly is in the filing fee. There's really no difference. Well, there's little difference in the procedure between a superior court, whether you're limited or unlimited. The difference in small claims is significant. First of all, lawyers are not even allowed in small claims court. I'm sure everybody's happy to hear that. And the rules of evidence, which are very strict in the superior court, are much more relaxed, meaning the judge will consider just about anything you bring in, and objections related to hearsay and authentication of documents, and all these rules that apply strictly in the upper courts don't apply in small claims, and which is why small claims is so appropriate for self-represented persons, landlords or tenants, or anybody else that has a claim. You just get to go in and tell your story, and the judge will listen to it and try to make sense of it and try to make a ruling that applies the law to the facts the judge believes actually occurred. Because often, obviously, in most cases, people present competing versions of the facts. In superior court, the rules of evidence preclude most unrepresented people from really effectively representing themselves, because they don't know those rules. And if you can't get your evidence admitted into evidence, if you can't get your lease or your rent rolls or whatever it may be admitted into evidence, you're just not going to get anywhere with your case. So small claims is your friend. And as I say at the bottom, the reasons for pursuing back rent in small claims versus superior really have more to do with the amount owed. If you can be in small claims, you probably should be. Small claims does allow an appellate provision. If you lose small claims, the defendant can appeal. The plaintiff can never appeal in small claims. If you lose, you just lose. But if the defendant loses, they have the right to file an appeal in small claims court. And in the appellate, the second bite, the appellate hearing, attorneys are allowed to represent claimants, whether it be the plaintiff or the defendant. But there's also some deeper issues, because the amount in dispute in small claims was increased by the state law that passed AB, oh my God, I've forgotten the name now. It's been a little while, AB 3038 in August of 2020, which I mentioned tried to bring some cohesion to the various local laws. But one of the things it did was it expanded the amount in dispute in small claims to an unlimited amount if it was unpaid rent that accrued during a moratorium period when the landlord could not pursue it in unlawful detainers. And those dates are basically March 2020 through, I think, September 2021. So depending on when your unpaid rent accrued, you may have to bring two separate actions in small claims. So it requires a little analysis, to be honest. So that's just a heads up. And back, you're still in Alameda County, so unpaid rent that accrued prior to April 30th, again, can never be pursued by unlawful detainer. And there's one issue, because almost all of the jurisdictions had restrictions on when even unpaid back rent could be pursued through a collections case. And again, unlawful detainer is the procedure by which a 3-day notice demanding the rent is served. The tenant doesn't pay the rent. The landlord is entitled to file that unlawful detainer, which is the formal expression for the eviction lawsuit. But it's not the only way to demand unpaid back rent from the tenant. It's just the one that most landlords prefer, because It is an expedited hearing, the 3-day notice, 5-day summons, that whole thing. Plus, if the tenant loses, the landlord recovers possession, which in many cases is the landlord's goal, as well as collecting the back rent. So the unpaid rent provision, if you're not going through unlawful detainer, but just through the collections procedure, Alameda County had a rule that the rent had to be unpaid at least 12 months before it could be subject to a collections. So I say any rent unpaid before August 22 could now be pursued via collection. So you have this sort of gray zone between August of 2022 and end of April 2023, when the rent could not be pursued by unlawful detainer. And according to the Alameda statute, it can't be pursued through collections because of that 12-month window that the tenant has to repay that rent. So that is going to run into this state law that, again, was passed, trying to bring some statewide cohesion, that says no matter what any local law says, the period for the tenant to complete repayment is August 31st, 2023. And I believe that provision is going to apply regardless of what any local law says, which just means if you wait till after August 31st and file your small claims case for any unpaid rent that you're not pursuing via an unlawful detainer, you're probably going to be legally permitted to do that. Some of this just waits for court rulings, and you may get different small claims judges making different rulings, depending on if the tenant even contests it. I mean, these are slightly technical arguments. I mean, they're not, it's not rocket science. I mean, some of the stuff I have started to call rocket science because it has gotten very complicated. But this is just whether the local law applies or the state law applies. And most judges are going to realize that the state law almost certainly is going to trump the local law on this particular issue. So if you wait till August 31st, I think you have a free hand in terms of collection actions. Then you just got to figure out whether you're going into small claims or regular superior court. Berkeley, and I have to give a shout out to my staff associate Bismay for providing the beautiful graphics. All right, Berkeley. Let me just move that from May 1st. So Berkeley changed its moratorium in the last couple of months, and basically starting May 1st, certain unlawful detainer actions were allowed, primarily owner move-ins, which we're not really here to talk about, but non-payment rent cases under a 3-day notice. Because as you may remember, for a long time, there were 15-day notices required and declarations and all of that stuff. But that's all fallen by the wayside for the most part, kind of other than as we're discussing here. But May 1st, landlords can serve 3-day notices for rent due after May 1st, but between May 1st and August 31st, that's called the transition period, tenants can defend a non-payment of rent case by proving a covered reason for delayed payment. And that's basically what we're I think there's a slide following that sort of details that, but basically it's just about anything the tenant can come up with that says, I can't pay the rent because of COVID. I don't know what that's going to be. I haven't seen one yet. The only one I can really think of, I mean, given the full employment situation, for a while, obviously so many people lost jobs because of the shutdown of the pandemic, but that, over 3 years ago, for the most part, anybody saying they can't get a job because of COVID, I can't imagine. So the only thing I can think of that would really present a viable defense is some sort of long COVID. I can't work, because of COVID. My thinking's foggy. My job that I used to have, I can't do. I mean, because I just really don't know what else is going to credibly demonstrate a COVID-related reason. I mean, there's a couple of others. Says, for example, if I'm taking care of a loved one who's affected by COVID, but again, those are more health related than they are financial. So I think anybody saying they can't pay the rent because COVID won't let them get a job because there's no job is just not gonna happen. And in Berkeley, like Alameda County, rent from the beginning of the pandemic, March of 2020, through May 1st here, as opposed to April 29th in Alameda County. They seem to march a little bit in lockstep here. Can never be sought by unlawful detainer. And again, that differs from Oakland. We're going to talk about in a moment. But and then as far as unpaid rent that accrued, it accrued depending on when it accrued. It determined when the deadline by which the tenant had to pay it before they could be subject to a collection action. And so here, anything from January 31st, 2021, before that, the tenants had, a year and change, 12 months, March 31st to pay it. After that, rent that accrued before January 31st could be sought through the collection procedure. For rent accruing between February 1st, 2021, after February 1st, 2021, I should say, tenants had until July 31st, 2023 to pay that unpaid rent. Now, obviously, rent that accrued as of May 1st was subject to a non-payment of rent notice, an eviction case, unless the tenant could demonstrate, the COVID-related defense. But basically, all unpaid rent that accrued up until July 31st can now be sought just as a few days ago by collection efforts. There it is. And this is the description of the covered reason for non-payment: a material decrease in household income. And again, I just don't see that being much of a very likely, just because, COVID is just not affecting businesses now. And then here's more of the out-of-pocket medical expenses, like, a reduction in the number of tenants living in the unit. Now that's an interesting thing. I guess a tenant could argue, I can't get anybody to sublet or be a co-tenant because they're afraid of COVID, and so they want to have testing. I guess, that's just who knows? Somebody would get creative, certainly, and try to do that. Well, the rent increase that exceeds the annual general adjustment, that's always a defense. Decrease in, caused by impacts of COVID-19 or any state or local or federal government response. So really, we're just gonna bring the cases and see what tenants come up with, and provide an update, probably, in a month or two. Some of those cases begin to percolate. And I'm still doing in Berkeley. I'm still doing just public health and safety cases, because a lot of my clients have decided they don't want to take the risk of filing an unlawful detainer only to have the tenant, produce some evidence that they have a COVID-related reason for non-payment, and then therefore defeat the case and cause them to basically spend their money for nothing. So I think a lot of my clients are waiting until actually August 31st, when all these protections finally terminate. All right, now we're in Oakland. Does that look like Oakland? Yes, it does. There's the courthouse. So the Oakland City Council, and as those of you who read the Q&A that Jeff pointed out, we'll have this stuff in those. I think June, July both covered this. So in addition to this PowerPoint presentation, you can always go back and refer there just for those details. But yeah, the City Council of Oakland finally decided to end the moratorium effective July 14th, 2023. There's a little bit of uncertainty right now because their website and their promulgations seem to have, they started with an August 31st termination date. Then it seemed like in the City Council they amended to July 14th. And then it seems like they may have gone back to August 31st. So I have had, diligent, intelligent staff people trying to figure out, is it July 14th, which is my understanding. But I've had a staff member say, no, here, see this, it went to August 31st. But I think that was an older version. But unlike some of the other jurisdictions that clearly update their statutes and their ordinances on their municipal code pages, Oakland's is maybe not quite as thorough. So, but I believe from everything I've read, July 14th is the end of the eviction moratorium in Oakland for all purposes. Now you can. So that's basically it. Just July 14th. It's all over, and you can start serving non-payment of rent. notices. But I think this is the next slide. So yeah, so 3-day notices to pay rent or quit after July 14th are permitted. But if you're seeking rent that accrued before July 14th, you got to include a form from the Rent Adjustment Program, the RAP office, and you got to include this specific language in your notice. Now, again, this is for 3-day notices after July 15th, seeking rent that came due before July 14th. So if you demand August rent, for example, you don't have to follow these guidelines. And the other, well, I just want to say the other, I got to go back. I don't think this made it into the slide, but one of the uncertainties in terms of the tension between Oakland and Alameda County is Oakland allows 3-day notices demanding rent that accrued during the moratorium, meaning rent that accrued but was unpaid before July 14th. However, Oakland has a defense to that if the tenant, like in Berkeley, and during the transition period, Oakland's transition period just lasts from the beginning of time until July 14th. The tenant can show that they can't pay the rent because of COVID, then that's a defense. And again, that defense concludes as of July 14th. So, and the tension is that, as I mentioned earlier, Alameda County does not allow non-payment of rent notices for any rent that accrued prior to April 29th, which was the end of the Alameda County moratorium. And the Alameda County moratorium said that it applied countywide, including incorporated cities like Oakland, unless those incorporated cities had their own moratorium protections that were stronger than Alameda County's. Most practitioners that I work with had long concluded that Berkeley and Oakland's moratoriums applied themselves because they were in some way stronger, or at least as strong as the Alameda County version. This latest amendment in Oakland calls that into question because, again, if Alameda County never allows evictions based on rent that accrued prior to April 29th, that would seem to be a stronger version than the Oakland version, which does allow evictions for pre-April 29th rent as long as it wasn't caused by COVID. So that's an issue for some judge and maybe some appellate court to decide. There just haven't been many appellate cases dealing with this stuff. One that came out in Southern California, but it's limited what's called precedential value, said that local rules will trump state rules on the COVID issues that are covered under the state law. It's a little confusing, and I could give a seminar on that, just to a bunch of lawyers, because it is confusing, and not to say that you guys wouldn't enjoy it either. But I don't know. I just say go for it and follow the local Oakland ordinance. And if somebody wants to raise the fact that the Alameda County version prevents you from demanding rent prior to April, they're going to bring it and then let a judge decide. That's all I can add. So as with Alameda County, Oakland states that you have 12 months, the tenant has 12 months before the unpaid rent can be sought. So again, just like Alameda County, any unpaid rent before August 2022 can be pursued through the collections case. But that leaves that void between August and July 14th in Oakland. So, but again, this entered by the state law says August 31st, 2023 is the end of any local ordinance that prescribes a delayed repayment period. I just got a little note that popped up, said my internet connection is unstable. I hope I am through and everybody's hearing me and I'm not freezing. I've had that occasion.
I think you're okay.
All right, good. Now I was doing a deposition remotely, and the other attorneys thing kept freezing up, which is where his client was, and we had to conclude it because it was just unworkable. So that alarmed me a little bit when I saw that note. Anyway, just talking about that collection thing in the 12-month, repayment period. I think if you wait till August 31st and you bring your collection case for any unpaid rent that you're not allowed to or choose not to pursue through the unlawful detainer procedure, I think you're going to be fined, because I think that state law is very clear, and state law always preempts local law when it's on the same topic. When the state law has made it clear that we're in charge here. So I think that's the bottom line. Just wait till August 31st, and any rent that you have from tenants that is unpaid during any period of time can be collected through the collections procedure. Again, whether you go to small claims court or superior court, is a separate determination. And well, this is another thing that you have to be aware of. This is causing a little concern. Part of when the Oakland City Council amended its moratorium to basically terminate it effective July 14th, they added a few other little things, but this one is kind of significant. Basically, you cannot demand unpaid rent until the amount that's due is at least 1 month of the HUD fair market rent, which is published by the HUD is Housing and Urban Development, which administers Section 8, which is the federal program for housing assistance to low-income tenants, and HUD publishes a fair rental value, because that's how they base the amount of assistance they provide for Section 8 tenants. And so that standard, which has never come into play in non-Section 8 housing issues, as far as I know, is now being used as the benchmark in Oakland for the amount of rent a tenant has to owe before an unlawful detainer notice, a 3-day notice, can be served. So you'll have to learn that information. And this most typically would come into place when a tenant's in a rent-controlled unit, so they've been there several years, and their rent is sometimes significantly below market. And just to take an example, if the tenant's been there 10 years and they pay $1,000 for a 1-bedroom, and you can now rent that for $2,000, because that's probably not uncommon, that tenant arguably can be 2 months behind in rent before you can serve a 3-day notice for non-payment rent. Previously, of course, you could serve a 3-day notice the second day of the rent was due and unpaid. So that's just something that has to be now factored in each case. But and as July 1st, 2024, the rent increase moratorium expires. So currently, all you can do is the annual increase. You can't do bank rent increases. I'm not sure about capital improvements. I think that is not affected, but definitely bank rent increases are on hold until July 1st, 2024. San Francisco. There it is. Thank you, Visme. I just love those graphics. A 3-day notice to pay rent. Now, this is basically copied from the San Francisco Rent Board's website, which is, I have to say, used to be, for me, a much more easily navigable, like user-friendly website. They changed it dramatically for reasons just don't make any sense. I mean, it was working. Why change it? Not sure what they paid, but I find it a little harder to find what I'm looking for now. But if you go to the eviction moratorium general, inquiry, they'll lead you to this. Basically, San Francisco it ended its total eviction moratorium as of end of December 2021. So then you could start doing owner move-ins again, breach of lease that weren't, rise to the level of public health and safety, pretty much everything. But non-payment of rent cases were subject to a defense, like we just talked about in Oakland and Berkeley, that the tenant could show they couldn't pay the rent because of COVID for one reason or another. Now, that is kind of weirdly broken down, because during the period, I think, of June 2021 until June of 2022, San Francisco allowed the state law to apply, which didn't have quite those same protections. That's when you had that thing where the tenant could pay 25%. And then, so it got a little confusing. But for the most part, rents that are unpaid in San Francisco can be sought by 3-day notice, but the tenant, at least up until August 30th, the end of this month, can demonstrate that they couldn't pay the rent because of COVID. just like we talked about in the Berkeley and Oakland versions. If they can demonstrate a covered reason for non-payment, that'll be a defense to a non-payment of rent case for rent that accrued through August 30th. Now, the uncertainty is after August 30th. Can you go back and start demanding rent before August 30th, and the tenants will still be able to apply that defense? I believe so, just like in Oakland. So rent that becomes due after August 30th, meaning basically September rent, is free of any of those defenses. So, but that's a little point that needs to be confirmed. If your tenant hasn't paid rent for June, July, August, September, do you need to do two notices? One for September, because it doesn't include any information that there's a defense for COVID-related non-payment, versus the 3 months of, I'm just picking three out of random, June, July, August, where the tenant has to be notified that if they didn't pay the rent because of COVID, that's a defense. And it's probably better to err on the side of providing that information. But again, we'll have that nailed down shortly. And this is just more information from the Rent Board's website. And here's the dates on March 16th through September 30th, 2020, or July 1st, 2022, and August 29th, 2023. I mean, these dates are related to the state law when San Francisco believed that it applied over San Francisco's version, which if San Francisco could have, they would have put in, more protection. And again, it's basically if the tenant can demonstrate that rent was unpaid due to the pandemic. So San Francisco the mayor finally ended its proclamation of local emergency. And when did that happen? I think it was at the end of June. And so there's a 60-day lag time between the end of the proclamation and the end of the moratorium rent payment and demand restrictions. So I hope that is clear. So this is just the same basic thing. In order for the eviction protections to apply, tenant's inability to pay rent must arise out of substantial decrease in household income caused by the COVID-19 pandemic or any local, federal, or state response to COVID-19. And in this case, as opposed to, for example, Oakland, the tenant must keep documentation showing their inability to pay was caused by COVID-19. Again, in the most recent months, with unemployment being practically, like at historic lows again, I think the only real likelihood of a tenant showing this is going to have to do with health issues. However, these protections only limit evictions and do not affect or waive the tenant's obligation to pay. Thus, a landlord may still bring a civil action in court to collect the unpaid rent. And unlike some of the other jurisdictions, there is no between this time and this time, tenant has 12 months. I mean, San Francisco just chose, for whatever reason, not to give a delayed repayment period. So the tenants are responsible for paying any unpaid rent that you can't collect through a non-payment of rent case. You can seek through the collection procedure. And that pretty much sums it up for the major jurisdictions of the Bay Area. Didn't have an opportunity to go into San Mateo and Santa Clara counties. They've been pretty much unrestricted for quite a while, so not much there to really cover. It really is San Francisco and East Bay that continues to have these restrictions, so that's why the focus was there. So I'm not sure. I think there's time if anybody has questions.
Okay, here
Recording
we
in
go. Now
progress.
we got it back up. All right. So looks like we had an internet issue there, and we've got that ironed out. And so one of the first things, and yes, so if you are watching today and you have a question, if you're watching from AOAUSA.com, there's a blue help button at the bottom. Uh, just put that question into, that's a little chat thing. Put your question in there. They'll get it to us. And if you're on YouTube or Facebook, just put it in the chat and they'll get that over to us. And one thing we were curious if you'd be able to share the slides with everybody.
Yeah, I'm happy to anybody want. In fact, I'll send it to who? Israel or you or
Yes,
because
send
to be
it.
honest,
Yeah.
to get 60 emails requesting, I'd rather just give it to AOA and let people come to AOA for it.
Okay. Yeah. So we'll take care of it. And what we'll try to do is maybe post a link to those pictures in the more part when you're on YouTube, the more part. So after the fact. So if you guys wait around a little while, hopefully we'll be able to get that up.
I
But
can email
definitely,
that to Israel now if that would be helpful.
yeah, sure. Why not? Go ahead and email him and we'll get
And
that.
he can post it as we speak because, this is the magic of technology, right?
Yeah, maybe if he's able to. We'll see if it takes
There
posting
you
it to our
go.
website and then sharing a link. Well, I'm not sure what all will be involved, but we'll at
Well,
least get
I've
it
done
in his
my part.
hands.
I
Yeah,
just
well, at
sent it.
least
So,
yeah, whoo, done. But no, really, Richard, thank you so much. You put a lot of time into that. There's a lot of preparation involved, and so we
well,
appreciate it.
there is, I had a secret conversation with Jeff before we started this. Some of this, I try to have assistants do because, I have other things and I had a particularly large project due today, in fact, and that had me and some staff scrambling. So you'll notice in the PowerPoint, there's some really beautiful graphic sections and then there's just some text boxes. That was me belatedly this morning, basically trying to make it a little more clear than I think it originally had been presented to me this morning. So yeah, that's in case you're wondering. But yeah, I think it's pretty clear. Try to keep it simple. Sometimes having these conversations previously, I walked away as confused as probably most of the listeners in some ways. So hopefully now, the light is, all the things are falling off, all the restrictions are terminating. So there's very few mysteries left at this point.
Yeah, really, the one on the 31st of August, whether
That's pretty much the end of everything everywhere.
yeah, well, that's the one that I'm really interested in seeing on how it happens because case case history would say that it's going to be the state's going to overrule everything else. But interesting that you mentioned that one about the Southern California ruling where the city overruled the state.
Well, that one Superior Court judge made that finding based on an interpretation of a statute that I would have gone the other way on. I would have, and I think if it went up to an appellate court, that judge would get reversed. I mean, I think, but again, that's statutory interpretation, and different judges come to different conclusions, and it takes a 3-panel appellate court to lay it to rest generally, and even they get overturned sometimes by the Supreme Court. Much less often, but certainly that's always a possibility. I mean, I've read cases where the trial judge was reversed by the appellate court was reversed by the Supreme Court, which makes a trial judge feel really good. I'm sure it's like, wow, it was right after all. So
Yeah.
because everybody takes pride in their intellectual like skill set, and I mean, I believe this and you believe that, and who's going to win is again up to somebody else.
Right. So it'll be interesting. That I think will be interesting. I'd be interested if you could dig that up, that one ruling in Southern California. I hadn't heard of that one. And
Oh,
so
yeah,
I'd like to look into that.
I'm happy to share that too. That's easy. Sure,
Yeah.
I'll send you that link. It'll take a little bit longer than it took to send the PowerPoint because the PowerPoint's right in front of me.
Yeah.
This one I got to go into some files. So,
All right. And then we have U2, or I'm sorry, not U2, UT on YouTube. I was under the impression that suing anyone is a fundamental right that cannot be relinquished. So how can politicians take this right away? I think he's referring to the unlawful detainer versus being just going to small claims court.
well, I mean, there's massive legal issues about all of the stuff that happened in COVID. I mean, from the federal response. I mean, you saw the Supreme Court, overturning some of the the health department's directives. I mean, these are just deep questions regarding our system of government. The federal, the state, and the local. What's constitutional? When can one do something versus the other? I mean, my favorite, because it was so applicable, was Alameda County trying to impose its moratorium on cities, because that's really outside the norm. Normally, counties, their jurisdiction extends to unincorporated parts of the county. Cities are their own little enclaves. Within the city limits, they get to do what they want. But Alameda County said, no, we're going to impose this. And so there was that big case out of the city of Alameda where the city of Alameda wanted to proceed against non-paying tenants. And this was the city that was renting to people, and it wanted to proceed. And the county said no. And so the city of Alameda sued the county and the supervisors, saying, your restrictions can't apply to us. And the appellate court kind of punted on it, and it kicked it back to the trial judge. And she just like, whatever, sure, go ahead. I mean, it was, and it was right about the time the Alameda County moratorium was going to lift anyway. So they didn't want to, I think, the county of Alameda spend a bunch of resources trying to defend a law that was about to expire anyway. But was that legitimate? I mean, to the question, who knows? It takes a 3-judge panel to ultimately, or the Supreme Court if it goes that high, and something like that probably should, because that was really it was a big legal issue about how much power can a county exert over its. But to the original question, I mean, people in places of influence or authority, make determinations. I hope best they can based on the information. I mean, I watched some of the San Francisco supervisors board of supervisors hearings, and they're debating whether they're preempted from doing this. And one supervisor says, "No, I don't think so. I've read," and they had the city attorney saying, "I think so." I mean, ultimately the city of San Francisco decided they were preempted, and so that's why you had those weird dates between when you could do something and when you couldn't.
All right, there we go. So Raymond on YouTube, Alameda County. Why is the eviction process taking so long? Our attorney already gave our tenant a violation notice and a 3-day notice, a 15-day period.
Can I just say, get in line?
Yeah.
I mean, we have default requests waiting in Alameda County, and according to either insider information, because one of my paralegals tries to stay on, she's got 300 default petitions. I mean, they're just overwhelmed. That's all there is to it. It's never been like this before, where you have so many cases pending, and so I mean, they would need to quadruple their staff to really start adequately handling these things, and that's probably not going to happen. So, yeah, it's just get in line.
Yeah, and it's a to have justice delayed like that is really not. It's really not justice.
I mean, unless the state emergency funds and a whole new category of court system. I mean, they could just fund a whole new category of unlawful detainer court system, because Alameda County has an unlawful detainer court. Not every jurisdiction does, but Alameda County is a dedicated unlawful detainer court, Department 511 in Hayward. That's where every unlawful detainer goes, no matter where it's located in the county. And there's one judge, and she is the gatekeeper, and she's got a couple of staff. Normally that was adequate, but again, I mean, from my paralegal, she said, yeah, they have about 300, default applications preceding hours, which has already been there for 2 weeks, 3 weeks. We get almost a daily email from the client. What's going on? Why can't you? I'm like, well, out of our hands, nothing we can do. You don't want to bug them, because you like to have the clerks kind of be, friendly towards you. And if you just keep harassing them, so, that's not good for all my other clients. So, I'm like, no, we're just in line. That's all we can do.
Sounds like we're a developing country and not a developed country.
Well, I mean, there's a lot of examples, but I don't know that. I mean, this one was just, they could have seen it coming. They could have seen they could have anticipated the deluge of unlawful detainer cases and applications and so on, and really staffed up for it. Like people staff up for big events. When there's a concert at Santa Clara, they run double trains, whatever. I mean. But I just don't think they did. Now, is that because they didn't have the money and there was just no way to do it? I mean, I guess. Or was there a political agenda? Like, well, we'll just slow roll these things because, we want to protect tenants. I don't think so. That would be the city council. And if they're the ones, and the Alameda Board of Supervisors, if they're the ones that are funding these efforts and they want to slow roll it, then yes, they can just not add funding and add more, personnel. But that's not really the court's fault. So I just, as an officer of the court, I just want to make it clear it's probably not their fault.
All right, Darius on Facebook. Can you go to small claims multiple times in chunks, say 6 months rent at a time to keep each under 10K? For example, if a tenant owes 24K, it's not COVID rent, can I do 3 separate small claims filing? I'm confused. Should we wait until September 1st?
That's a great question. That's a great question.
And they're in San Leandro is where they're at.
Yeah, well, I don't know that it matters. I mean, San Leandro has its own little thing going, but not really. Now that, I need, or somebody needs to, it's probably been done by somebody else, whether it be the court system or another firm, to outline in detail that particular scenario. Like, how much can I claim if it became during this period? And that's a chart that, I think I will work with AOA to develop, which is to say, we're going to give you something that's very clear in terms of how many times can you, because it used to be a limit of 2 times, for cases that were over 2,500. And so I think if we work together, Jeff, we can provide a nice little chart that really explains that. So questioner, give us a minute.
Yeah, let's give it a shot. And also, I mean, it seems like I think it was AB 3088, it said that small claims court had just opened it up. So I kind of thought that could just be in one shot. He said it was not COVID rent debt. So that's confusing in the sense that we've been in a COVID period for so long.
The state law that relaxed the jurisdictional limits in small claims to allow for any amount to be sought if it was COVID-related rent debt also had periods. And I think that was from March of 2020 through September of 2021.
Okay.
So if your unpaid rent came due during that period, it didn't matter if it was $100,000, you could bring it in small claims.
Okay, that had a limit to it. Okay, I see.
So that's the chart. I think if we work together, we can provide in a nice, easy, bite-sized graphical, thing that will make it very clear when you can go to small claims for what amount, for what periods.
Right.
And how many times. Because, obviously if you have different tenants, you have to file different claims. You can't lump all the tenants together.
Well, great. Thank you for putting that together for us. And,
it always helps me understand it too when I have to explain it to people.
Right. Yeah. And so hopefully that helped everybody. And let me see. I see your numbers there on the screen. 510 548 7474. You got your email and your website.
Familiar.
Yeah, it probably sounds super familiar. So all that's
actually
there.
Sometimes I have to look. I keep a little card on my desk just in case, because my address, I'll be honest, sometimes I'm like, where's our office? Because I haven't been there in 3 years. I mean, it feels like I haven't been there in 3 years because COVID was a thing here too. So at any rate, you should have my information if you have specific questions and so on. And there's the AOA Q&A portal, right? And I have to apologize. I still don't understand this, but I've gotten a lot of questions that get directed into my spam folder, which, I used to never check because I didn't care. And then somehow I discovered that some AOA inquiries were going there. So for those of you who've not gotten a response from me in a day or 2 days or 5 days, that's almost certainly the reason. And you can go to my website because we also have an inquiry page. So, so you can do that. If you don't hear from me through the AOA version, it just means literally it got misdirected and I haven't checked it.
Right. And maybe you can add to your contacts, whichever email address that's coming from. It's membership at AOAUSA.com or info at AOA.
Oh, right. If you want to, make a note if your inquiry comes through my website, you might want to say, hey, I'm an AOA member. I sent this through their portal, but I haven't heard from you. What's going on?
Oh, no. For you specifically, if you add that email address that you're finding in spam, if you add it to your contacts.
No, I've done everything I can. I mean, I have a tech person and I've worked with your side, and it's just the weirdest thing. I'll be honest. I think I've gotten them. They've started coming through to my, directly into my inbox. No, I
Okay.
mean, I've done the whole thing. Like if you find something in the junk, you move it and it says, this will
Yeah.
make it a safe thing. And I'm like, I've been doing that for, a while, and it just hasn't made a difference. So at any rate, that's all. I just leave it at
Well,
that. And I'll try to check my spam folder, a little bit more often.
well, thank you so much for supporting the members there in the Bay Area, and for
Sure.
doing the in-person seminars, doing these online, for helping Allison in the Alameda office. So thank you for all
Oh,
of
it's always
that.
a pleasure to work with Allison.
Yeah, she's
She's been
great.
great.
She really is. And so thanks again. And
Okay.
thanks everybody for listening. And hopefully I'll see you guys in September. And I'll for sure see you in September.
Okay.
I believe. I think
Probably
we
on
have.
the calendar. And one of
Yeah, I
these
think we have
days,
something
I'm
in.
dropping by the offices. So,
Yeah. Okay.
and we were so close last time. Anyway, all right, Jen.
All right. Take care.
Bye bye.
Bye.